In a recent blog, I spoke about children and the law of liability when children are engaged in youth activities. I'd like to develop that principle a little further and today talk about a very important decision of the highest court of Massachusetts. It was Sharon versus City of Newton. And the young woman there was a cheerleader, and she got hurt in an after-school cheerleading activity and sued the City of Newton. She sued when she became of majority age. And there are a couple of things at issue, and I think they're relevant when we think about claims for children or on behalf of children. The first is that her father signed a release as a condition of his daughter's activity. In the court, the Supreme Judicial Court wanted to determine whether a parent could release the rights of a child away. And at common law, the court says, that is, over the years, those releases were unenforceable against a minor, that a minor could still sue. But here, the highest court of Massachusetts said that no, in fact, the parent, the father, could indeed contract the right of his daughter to sue. And the court felt that with respect to the permissibility of requiring releases as a condition of voluntary participation in extracurricular sports activities, that the parents who signed a release and enforcing those releases is consistent with and furthers the public policy of encouraging athletic programs for the youth of Massachusetts. So therefore, the court is looking at what they feel is an important public policy, having orderly and cost-effective programs that are run for our youth. And if it means that negligent suits cannot be brought, that is the trade-off. So the court made a decision that is harmful, in effect, to the rights of people who would sue for negligence. Keep in mind, you can still sue, or your child could still sue for gross negligence. And the other item that I want to bring to your attention is the court said, well, will this remove any incentive on the part of the cities and towns to act in a careful manner? And they said no, that the pressure from the city or town and the public's governing right to govern, through the electoral process and otherwise, will exert a positive influence. And they also looked at statutes in Massachusetts that exempt from negligence municipalities who own land, people who permit recreation on their land, and, as I discussed in a prior blog, exempt from negligence nonprofit organizations and volunteer managers and coaches who offer and run for sports programs for children under 18. And they said to impose a different standard on a city or town as compared with those other statutes would create an anomaly or an oddity in the law, and this they weren't willing to do. Thank you.